My name's Tristan Blythe and I'm editor of Charity Finance. And I'm joined today by Gordon Reid, who is partner and head of charities at Barlow, and David Ludlow, who's a partner at the firm. They're going to provide us with a legal update, which will take roughly half of the session, with the second half available for Q&A. So please, whilst Gordon and David are speaking, feel free to submit your questions. And once they've completed their presentation, I will then come back and put the questions to them. So yeah, please get involved. We want to make this as interactive and as lively as possible. But without any further ado, I will now hand over to Gordon, who will start the presentation. Gordon.
Tristan, thank you very much, and a very good morning to all of you watching. Thank you for joining us. It really is a great pleasure for us to be supporting Civil Society's Faith Week, and I hope you enjoy the very varied and interesting programme they've lined up. This just gives you an idea of where we're going in the next half an hour or so. We have slightly changed the order, so the HR and employment issues, which David will cover, will come at the end after my slide on the future and before questions, but that's the broad direction of travel. So let me kick off then with some thoughts on good governance. Good governance is not a bureaucratic detail. Tim Hopkins from the Charity Commission made this comment on the publication of the Charity Commission's report at the end of its inquiry into the charity known as Aid Convoy. The circumstances surrounding that inquiry and the charity and the things which led to it were pretty extreme, with the Commission concluding that the trustees had committed repeated acts of mismanagement and misconduct. And I very much hope that we're none of us facing quite that sort of situation at the moment in the charities which we represent. But the general principle is important. Making sure that things are done properly in the right way is essentially what good governance is all about. So it's not just for the geeks who are obsessed about administration and paperwork and filing things. It's not just for the bureaucrats who like everything shipshape and in order. It needs to be at the heart of every single charity. And no matter how well we're doing, we can always take a look and we can hopefully do better. This is just a summary, things hopefully you'll know as to how trustees go about their job of overseeing their charity, always acting in the best interest of the charity with reasonable skill and care and prudently. So trustees bring their individual skills to the table. You don't overnight on being appointed a trustee have to suddenly come up with new skills you knew nothing about. You bring the skills you have to serve the charity, and you use those carefully, and you together use them prudently. You want to make sure that you're not making decisions which are going to put the charity at risk, which are going to potentially cause problems down the line for future generations. So that's where the prudence comes in. Charity law is made up of lots of wonderful ancient cases. I think the one which established the principle of prudence goes back to about 1893, and it served us well since then. So those three principles underpin everything charity trustees do as they go about overseeing their charities. And this may seem obvious, but everything you do as a charity has to be done in line with your governing document. It essentially is your rule book. So when was the last time you had a look at your governing document and saw what your objects are, reminded yourself of the sort of powers you have? Because you can only spend the charity's money in pursuit of the objects that are listed in your governing document. And you can only use the powers you have been given by your governing document. So has there over the years been some mission creep? Have you sort of stretched the scope of the work your charity is doing? Has that expanded over time? Has your governing document kept pace with the sort of things you are doing at the moment or you would like to do? You really ought to review that. You want to make sure that your governing document is in line with what you're doing and is up to date with the powers and the scope you need. So do review it if you haven't done so for a while. Just since 2000, there have been 3 pieces of charities legislation and at least 1 Companies Act. So there will undoubtedly be some amending and updating you need and would like to do. And then you'll undoubtedly have a whole raft of policies that assist you in going about your day-to-day work. And often policies gloriously languish in the old days in desk drawers and in their virtual equivalent these days. So please make sure you are keeping your day-to-day operating policies up to date and reviewing them regularly so that they live and breathe and help you fulfill your mission and deliver your purposes. It will be hugely helpful for trustees to undertake training regularly so that they can be clear about their duties and responsibilities, and also keep up to date with charity law and practice, because things do evolve and there are some changes from time to time that you really need to keep up with. Civil society runs an excellent series of courses on governance and leadership and all the facets of that, including finance and all the different areas you're likely to come across. So do have a look at their materials. You'll find that your law firm and your accountants may well do courses as well, which they might provide free to you as their clients. And it's really worth following those up and seeing what you can use. And especially if you're new to being a trustee, do make sure you ask to be sent on some training so that you can really benefit from all the experience that's out there and feel equipped to do the best job you possibly can. There ought to be a clear process for recruiting and selecting new trustees. There needs to be a succession plan in place so that you have a nice steady throughput for new trustees, and you want to make sure that especially your chair and your vice chair, if you have them, you don't suddenly find yourself 2 days before their retirement having to try and replace the chair. So do think about having a succession plan in place, and do think about the diverse makeup of your trustee board. The word diversity is used a lot these days, but the reality is we want to draw on as much experience as we can from different parts of our communities, people who have different things to say and different perspectives, helping us run our charities as best we can run them. And then I talk here about a health check. I think it's just important that you regularly check and review the way you run your administrative processes, the way you keep your minutes in particular, and the records of your charity. It's very easy to fall into one of two traps. You either have the tersest, shortest possible minutes that just record, we decided X, or you have the other extreme, which is War and Peace, where some poor soul is writing down every twist and turn of every comment that anyone ever made on the subject. And in the midst of all that, the decision that's made and the reasons for it get lost. And one of the really important things that the Charity Commission likes to see is a bit of explanation as to why you've made the decision you've made. So sometimes it is just worth, especially if it's been a tricky decision or it's quite a major departure for your charity, spell out why you've chosen to do it. Why is it in the best interest of the charity to take that particular decision? So the people who come after you a year, 2 years down the line understand the reason why you've made the decision you've made. Or if you find yourself in the unfortunate position of a Charity Commission investigation for some reason or another, the first place the Commission will go is your meeting minutes. They'll want to see what you've done and why you've done it. And if there's no explanation as to how you've reached the decision you've reached, they may be concerned. They may have some questions for you about that. You may be familiar with the Charity Governance Code, and that's something which was put together a few years ago by sector bodies across the sector, aiming for something that just really set a benchmark, set best practice for charity governance. If you've never had cause to look at that, you can find it easily online. It's free of charge. Do have a look at that. And we here at Barlow have put together a Charity Governance Code checklist. It's essentially a tool to allow you to evaluate the performance of your board and your charity against those standards, those benchmarks that the Charity Governance Code set. And if you'd like to have a copy of our code checklist, please do feel free to drop me an email. Contact details will be at the end of this or on the chat, and I'll note your name and details and I can get that across to you. The code was due to be updated this July. Like many other things, the progress of that updating has been slowed somewhat. There's just going to be some tidying up done in relation to that, but it should be a major review will be following in the coming months, so look out for that. But in the meantime, have a look at that. It will be of real help to you, I'm sure. And then just very quickly to touch on the current pandemic and governance help that's come from both central government and the Charity Commission. I think it's fair to say that flexibility has been the watchword from the Commission on the sort of tricky things people have found, suddenly not able to meet physically to conduct the charity's business or an AGM, and the Corporate Insolvency and Governance Act 2020 for charitable companies gave some flexibility and ability to hold meetings by electronic means where the governing document didn't allow. And although there's nothing quite similar for unincorporated charities, the Commission has said they will take a flexible approach and they'll support charities who've decided they've got to meet by Zoom or whatever. But they ask again that you simply record the reasons for deciding to do that. And they will help you on that. There are some changes to or some help on filing deadlines, the ability to ask for an extension on filing your accounts if you're running behind because of the pandemic. Again, the golden rule there is please apply for the extension of time before the deadline passes. They will look much more favourably at Companies House on your application if you do it that way round, and then after you've fallen foul of the deadline, suddenly wake up to the fact you haven't met it as you should. I'm just going to then move on very quickly to say something on safeguarding. There's a major session I know coming up this afternoon on safeguarding, but I just wanted quickly to highlight for you, in case you'd not realised, that the scope of safeguarding, so far as the Charity Commission is concerned, has been extended and widened significantly in recent years. We've gone. We began our safeguarding world thinking of children and vulnerable adults. That was the expression used at the time. Charity Commission guidance now takes you well beyond that. So you have a duty of safeguarding for your staff, for your volunteers, your beneficiaries, any visitors to your charity's premises in the glory days when those were allowed, and hopefully they will be again. So you just need to be aware of that. Now, clearly, the extent of your safeguarding duty will vary depending on who you're dealing with. But you just need to be aware and alive to the need for that. You should have safeguarding policies and procedures, and you want to make sure that those are alive and well and breathing. You want to make sure that the culture of your organisation actually reflects what your policies say. There's nothing worse than beautifully crafted policies which aren't actually lived out and breathed in the charity itself. So make sure there's no disconnect between what you do and what you say you do in your policies. And do give your staff, your volunteers, training on these potentially tricky and challenging areas. There's one last comment from me before we get on to the employment and HR side of things, and that's really just to prompt some thinking, maybe some questions about the future. Is it going to be back to business as usual just as quickly as you can manage it when this wretched pandemic finally does its worst and passes on? Or is now the time to realise that after these last 6 months, you may need to do things differently to make a better and more effective use of your charity's resources? Have you discovered in these last 6 months that actually the power of collaboration between you and charities in neighbouring towns and villages or locations has been really helpful and powerful and allowed you to do a lot more? And might you want to consider more formal collaborations moving forward? Might you also want to consider a full-blown merger with another charity? Money is tight. We're here every single day. We see it in the civil society news every day, large charities really struggling with donation income. And all charities, large and small, are going to be facing that challenge. So is now the time to think about planning for the future, securing your future with a merger, perhaps? Those are big questions. You shouldn't embark on them, as the old Church of England marriage service said, you shouldn't embark upon them carelessly or lightly or without serious thought. But they are certainly things you should be thinking about. They are things that should be on the trustee board agenda as you think about your strategy for the longer term. So just a little word about that. And obviously, you'll need advice from your lawyers, from your accountants about the mechanics of merger and the merger process, because there are some twists and turns to be aware of. But keep that on your radar. That's a very rapid canter over some governance issues, and my apologies that by definition it's got to be so quick, but hopefully that's given some food for thought, and delighted to take questions. And I know there have been some popping up as I've been speaking, but I'm going to hand on now to my partner David Ludlow, who will look at some employment and HR issues with you.
Good morning, everybody. I'm going to look first at general secular and faith-wide sector employment law issues, and then I'll move on to more esoteric faith organization-focused issues. The current challenges that we face, of course, are COVID-related, and as you probably all know and have experience of, that we're winding down the coronavirus job retention scheme, the furlough scheme, which on many levels has been very successful. When that comes to an end at the end of October, the employer, having shared the pain, of course, in September and October by having to pay first 10% and then 20% of the furlough 80% entitlement, the organizations are going to focus on redundancies. Indeed, they already are. But think about other measures, steps you can take to make your organizations, I was about to say more profitable, but you know as I mean, viable, instead of redundancies, which is obviously a step of last resort. For example, changing terms and conditions to enable people to work part-time to save wages, temporary reduction in pay, short time working, flexible working, early retirement, delay in paying bonuses, sabbatical or unpaid leave in these extraordinary times, the withdrawal of non-contractual benefits, and also, of course, what we've all been doing for some time now, requiring staff to take their annual leave as it accrues. A very topical issue now is the requirement to return to work, because government and employers are broadly encouraging people to return to their place of work, their offices. And in that context, bear in mind the rights that employees have under Section 44 and Section 100 of the Employment Rights Act, which is protection from detriment and protection from dismissal in circumstances in which they are required to attend work, even though they may have a reasonable belief of imminent danger because of the coronavirus. And so I've set the things that you should consider out there. Is the danger the general existence of COVID-19, or are there workplace specific issues? What level of risk assessment has been done? What protective measures have been put in place? The perception of the importance of work. Are you involved in frontline key worker activity? And indeed the dangers on the journey to work. And in the context of risk assessment, which by the way is key to protecting your organizations, of course that extends to your volunteers as well, and perhaps primarily as your staff. And then, without being gloomy, some interesting developments in the law on insolvency and administration. Two recent cases, Carluccio, which went bust, and Debenhams, which went bust, went into administration. And the courts have just established that administrators adopt the contracts of employment of employees when furloughing. And the principle behind that is, of course, the rescue culture. So moving on, let's now look at more esoteric faith-based issues. charities and faith-based organizations have to deal with a number of specific issues, and very recently the United Kingdom Supreme Court has handed down its judgment in this groundbreaking case, Gillam versus the Ministry of Justice. I won't give you the facts. It's a very important recent case because it establishes, or virtually establishes, it's going to give rise to a lot of case law. Trustees, volunteers, and clergy are protected from whistleblowing detriment, even though they may not be employees or workers. There is now judicial recognition that an occupational classification might amount to an other status apart from employee and worker for the purposes of Article 14 of the European Convention on Human Rights, and is likely to result in trustees, volunteers, and members of the clergy being protected. There's no Brexit issue, of course, because the United Kingdom will remain a signatory to the European Convention of Human Rights. And it is inevitable that it will now be argued that this principle extends to other rights reserved for employees or workers claiming discrimination. So whereas that last bullet point there, up until now, the law has been that volunteers, pure volunteers, are not protected from discrimination, that is likely to change, indeed may well already have changed as a result of this decision. So moving on, of course, like all employees and service providers, faith-based organizations must overcome bias within their organizations. The prohibition of discrimination on grounds of a person's religion or any religious or philosophical belief is just one area. There is a need to avoid less favorable treatment of employees, and as I've just said, quite probably, I would say, volunteers, because of religion or any religious or philosophical belief. We're all familiar with the genuine occupational requirements that may provide a defense in relation to recruitment or retention, but there could be a wide range of other acts or omissions that fall foul of this law. The law stems from the European Convention of Human Rights, and in particular Article 9, the right to freedom of religion, Article 10, the right to freedom of expression, and Articles 14 and 17, which outlaw discrimination and the destruction of European Convention of Human Rights rights. So looking now at the scope of philosophical belief, it's very broad, and it extends to faiths beyond religions, or indeed even akin to religions. It now encompasses a wide range of secular beliefs that could not have been envisaged when the legislation came in 2003, or indeed when it was extended in 2010. For example, climate change, veganism, the higher purpose of public broadcasting to promote cultural interchange and social cohesion, left-wing democratic socialism, but not membership of the Labour Party, of course, Scottish independence, but not membership of the Scottish Nationalist Party, republicanism, and belief in the abhorrence of domestic violence towards women and the sexual abuse of children are just a few examples of philosophical belief, or beliefs that people have had which have been found to be philosophical beliefs within the terms of the legislation. But as I say, purely political beliefs and lifestyle choices such as vegetarianism will not qualify, nor will beliefs or philosophies that entail disrespect for or challenge the rights of others. And of course, that's crucial because that rules out extreme beliefs or faiths like Nazism, to take an extreme example, fascism. And so moving on, the conscientious objection to transgenderism, the conviction that biological sex as opposed to gender is binary and immutable. Nazism, fascism, English nationalism are not covered. Of course, it is not always the manifestation of the belief or the faith that is protected. In cases concerning proselytization, I think I've got that right, and expression of religious views that amount to harassment of others, courts have readily distinguished between belief itself and the claimant's actions consequent upon the belief. And so you're all familiar with the AWIDA British Airways case, the air hostess who insisted on being able to wear a cross around her neck, notwithstanding British Airways dress code. The European Court of Human Rights established that she is entitled to manifest her religion in that way, and that the British Airways policy was not a proportionate means of achieving the legitimate aim of a standardized secular, if you like, dress code, or a safe dress code indeed. It was disproportionate. Contrast that with the case of John Ball and Liverpool City Council, where a social worker sought to foist his fairly orthodox Christian beliefs on the service users. He was dismissed for that reason because he did so in breach of the council's policy, and not, of course, because of his religion or beliefs. Finally, note the case of Gan Menachem Hendon, which is an Orthodox Jewish organization, where they terminated the employment of one of their workers who lived with her boyfriend outside of marriage, which was contrary to their fundamental beliefs. The ratio of that case, the thrust of that case, is the very important and perhaps obvious point that treating people less favorably because of the employer's own belief does not contradict or offend and is not prohibited by the less favorable treatment of people because of religious belief regulations. And finally, I'd like to just mention the recent cases. You've probably seen some coverage of the Barclays Bank case and the more high profile Morrison's case, Morrison's supermarket, where a rogue employee put on the World Wide Web 100,000 employees' details, personal details, and a group of those employees sued Morrison's on the grounds that they were vicariously liable for his acts. Morrison said, no, those acts were right outside the course of employment. And what these interesting, again, Supreme Court and very recent decisions do is that they restore to reasonable bounds and go back to a more doctrinaire approach on vicarious liability, which in practice is going to help religious faith-based organizations defeat claims by members of their staff and, as I say, volunteers. So that is all that I have to say, and I look forward to answering any questions you may have.
Okay, thank you very much, Gordon and David. Very interesting presentation, lots to think about there. I'm sure there's lots of questions, so please do jump in and start putting your questions forward. As Gordon mentioned, we've had a couple come in already. And probably the first one to deal with is the link between good governance and faith, and in particular, whether faith would be considered a good reason for making decisions, and whether the Charity Commission would accept that if the meeting minutes confirmed that. Gordon, I wonder if you had any thoughts on that initially.
Thanks, Tristan, and thanks for those really good questions. The straight answer, which is not a straight answer at all, unfortunately, is that it depends. So on the latter question about whether the Commission would accept it, but just to take one step back, how good governance and faith interlink. Clearly, faith-based organisations and charities will have faith at the heart of their organisation and purpose, and therefore they'll be pursuing them in the normal course of what they do. But that doesn't mean that the principles of good governance, which I outlined, somehow go out the window because it's a faith-based organisation and somehow there's a higher calling. I wrote a little piece for Charity Finance magazine, which came out just at the beginning of September. And in there, I highlighted the fact that many of the Charity Commission inquiries that are opened are actually into faith-based organisations, because sadly, some think that they're slightly above the law because they're answerable only to a higher power of whatever faith persuasion. And so I suppose I really want to strongly argue faith charities should be concentrating on good governance. But good governance doesn't stop you running your faith organization. And so you may have a spiritual leader if you're a church or a congregation, a mosque, a synagogue, and they have their responsibilities under the tenets of your religion. But those can sit perfectly happily alongside trustees' responsibilities to the wider law of the land. So that's how they interlink. You have to just make sure that the things that are responsibility of charity trustees under charity law are not somehow given to someone else who has no responsibility for them, or that someone else who is not a trustee is wielding undue influence over the issues that are properly legal for trustees, as opposed to the faith element of the organisation. And then the point about the faith being considered a good reason for making decisions. Well, if you're pursuing your charitable objects, and your charitable objects are to advance your faith by whatever it happens to consist of, then making decisions based on your objects, of course, are perfectly legitimate and should be properly taken into account in the way you deal with in the way you deal with the things that are before you. Faith won't necessarily, you shouldn't view faith as somehow a get out of jail free card, for want of a better expression, that somehow allows you to be a bit flexible with what you do and why you do it. A faith organisation still has a governing document, it still has the rules of that governing document, and it still has to work within the confines of them. I hope that helps.
Brilliant, thank you, Gordon. One thing you mentioned, Gordon, that I wanted to ask you about is you spoke about the importance of diversity on a board. I was just wondering whether there was any, and perhaps David would have some thoughts on this as well, but any good practice you've seen on ways of ensuring you have that diversity and, perhaps recruitment methods and things like that?
Well, I think David will obviously comment in a moment. I think it's a challenge. I think, lots of, I do quite a lot of training locally for trustee bodies and local associations of voluntary organisations. And I think lots of people would say, we'd love to have a more diverse board, but we can't get people of working age or younger people because they're working and because they've got commitments, or we can't get people from ethnic minority backgrounds because they don't live in our location, or whatever it might be. So it is a challenge for sure. But I think what we're trying to promote there is the idea that, don't just think that when you come to recruit new trustees, well, it's your mates, it's the people you know, and that'll be easy because you know these people and they're going to be good and capable of doing the job. You need to stop and think and cast your net a bit more widely. So there are a number of organisations that you can find that will help you recruit trustees and find a broader range of trustees. So the NCVO, for example, helps in that way, and there are various other organisations, you'll find them on the web, where you can look to for some help on recruiting trustees. Some of those local voluntary organisations I mentioned, most boroughs or counties will have an organisation committed to supporting voluntary organisations, and they will tend to be quite a good source to go to ask about a more broad and more diverse body of trustees for your particular organisation. But all of those things are worth thinking about. David, I don't know what you have, if you have any thoughts on that.
Yes, I agree. I agree with the observation that in this day and age, for whatever reason, perhaps because younger people are so busy, that many charitable organizations, board of trustees and directors are made up of senior people. I'm thinking of the charity that I'm a trustee of, and there is partly the incumbency factor there, that many of them, of course, stay on for years and years. But as a matter of basic principle, any organization, charitable organization, would be well advised to adopt an equal opportunities policy now, particularly in light of the jurisprudence that I've just discussed, those Supreme Court decisions which are hot off the press. And consider, because after all, trustees are volunteers. And so trustees will be protected from discrimination. In other words, the opportunity to join the board, to join an organization as a trustee in their capacity as volunteers, and also in their capacity as trustees in terms of retention, incumbent trustees. So draw up an equal opportunities policy. That we have found that our equal opportunities policy in the charity that I am a trustee of naturally extends beyond our staff, beyond our employees, to volunteers at different levels, and that will afford you a good degree of protection. I think we often say in employment law that if you don't have an equal opportunities policy, you start 1-0 down in any legal challenge, and it is undoubtedly the starting point, the most obvious step that you can take, not just negatively to protect your organization from claims, but to actually achieve diversity. And ensure you have representatives from every gender and every age, as far as possible, and also, of course, religion and philosophical belief.
Thank you, guys. Yeah, we've had a couple of comments come in whilst you were giving your answer there around that final point, David, of diversity of beliefs and whether faith-based organisations should have that, and comments that there's a number of organisations that say that their rules, the trustees have to be from the same religion. Is that something that you think should change, and are you seeing that changing? Is that an important element of diversity? Because, as you say, diversity is a broad topic.
Well, yes. Sorry, David.
Yeah, I would say it is an important element of diversity in society, and it goes to fundamental human rights, of course. The rights that I've identified in the European Convention of Human Rights, Article 9, the right to hold and express one's own religious belief, and Article 10, the right to expression of belief, and the right to association, of course. And the law recognizes that. If you think about the general the genuine occupational requirements, there are two types of genuine occupational requirement. The first, defence. The first is the general defence, which applies to organisations operating in a particular field, and the more specific employer defence extends to those organisations that exist for the purpose of an organised religion. Both of those defences will serve to protect faith-based organisations that feel it is necessary to recruit trustees and volunteers only from the sectors of society that adhere to their particular faith.
Gordon, sorry, did you want to come in on?
Yeah, I was just going to observe. I mean, I think your starting place there, of course, needs to be your governing document, because it will have some things to say. First, note the nature of the object. If the object is to promote a particular faith in various ways, then I think it would be difficult for someone who didn't share that faith, who had no faith or has a different faith, to sign up to, as it were, acting in the best interest of that charity and pursuing its object of advancing that particular religion. So that's one place to start. But if it's a more general, I think watching the chat, a lady mentioning that the charity is Catholic, but beneficiaries can be of any faith. Well, what does the object say? What do the rule books say about requirements for trustees? It may be that you don't need to be a Catholic to dispense grants in that particular context, but there may be good reason for requiring that. So start with the governing document and then take some advice if need be, I would say.
Okay, thank you. A different topic now. We've had a question which asks whether the test cases that you've mentioned, or if some of them will help with the risk of unlimited liabilities for trustees of unincorporated charities.
That's an interesting question. That, of course, all of the discrimination legislation, in principle, extends to the individual offenders. Indeed, the legislation is posited on the basis that the perpetrator is liable, and the employer is deemed to have aided and abetted the perpetrator. And so increasingly we're seeing in a number of areas of law, particularly in relation to whistleblowing, in fact, liability being full liability being extended to individuals who directors. And in principle, that will extend, Gordon, I think, to directors of companies limited by guarantee, and for the reasons I've given earlier in the talk, will now extend to trustees and volunteers. But yes, there is scope for individual personal liability, but those things can be managed, of course, through directors and officers, insurance, and so on. Gordon, do you agree with that?
Yes, I mean, I think certainly you can. Unincorporated charities can seek and obtain trustee indemnity insurance, which will give protection for the sort of core stuff, provided you go about your duties in the right sort of way. No insurance policy will protect you from fraud or recklessness or criminal behaviour and like that, nor would a limited liability framework in a company limited by guarantee or a charitable incorporated organisation. But on the face of it, you can seek insurance certainly to give you protection, and I would say it's worth doing if you remain convinced that the unincorporated model is the way forward. Then I think you certainly want to think about taking out insurance. You might, as a tangent to that, want to think about incorporating with a limited liability framework, because anecdotally I hear from charities that they find it difficult to recruit trustees anyway, but when they are unincorporated with potentially unlimited liability for trustees, then it makes it even harder. People just hear that and think, well, I'm going to give some time to this, but I'm not prepared to sort of see my house go when it all goes horribly wrong. So that's the extreme end, of course it is, but there is an element of that in people's thought process. So I would just encourage you to think about the issue of incorporation, depending, of course, on what your charity does. But it may be sensible, partly as a means of trustee recruitment and partly also in giving you that protection of the limited liability framework that those two things provide.
Okay, thank you both. Another question here about possible staff savings and what the best practice is in terms of discussion with potential retirees. The issue that's sort of been raised is that given that staff in faith charities are motivated by their faith, they can quite often be keen to keep working beyond the state pension age. And these discussions about possibly retiring can be difficult with fear of discrimination, particularly if it's an organisation that doesn't have a dedicated HR team. So perhaps if I can come to you first, David, on that, what's your feelings on those discussions?
Yeah, my feeling is that the starting point is that people who are getting on and up to and beyond, what we used to call the normal retirement age of 65, for example, have to be treated very carefully and in a non-discriminatory way. And that is becoming more and more so with each year that passes, because people are living longer and are much more capable in later life of discharging their duties. And so any charity or organization has to be careful, very careful about enforcing retirement on trustees at 65. But the basic legal position is that if an organization has a policy of retiring people at age 65 in order, for example, to achieve intergenerational harmony, in order to bring on new younger trustees, even in order to change its outlook and practical experience of life and providing services in modern British society, then very probably such a policy will be a legitimate aim and a well thought out and recorded, documented decision to compulsorily retire a trustee would probably or could be a proportionate means of achieving that legitimate aim. And that is the test, of course, that a discriminatory policy can be justified, an age discriminatory policy can be justified. Age discrimination is one of the very few areas of discrimination that can be justified, and it can be if the policy that is adopted or the measure is a proportionate means of achieving those legitimate aims, one or two of which I outlined.
Okay, thank you, David. Just want to go back to the question of diversity on boards and faith, because we've had quite a few comments coming in on that, including from one charity who says they're a Christian organisation, but they don't require trustees or staff to be Christian, but to share their fundamental values. And a question, because we've got a few minutes left, the distinction on this same topic, the distinction between the spiritual faith leaders and trustees is important. So what if these are the same individuals? Gordon, how would you deal with that?
Right. Yes, just to finish off on the question of people of different faiths being trustees of other faith organisations. I mean, I think it does fundamentally come back to what the organisation concerned is about. Obviously, I don't have the detail on that, but the object, what they're seeking to achieve. So your local church, for example, that is a charity. If it's Catholic Church promoting the Catholic faith, then it would be difficult for someone of another faith to have oversight in that. But if it's a welfare organisation or a leaf organisation, absolutely, there could well be a place. So just revisit your governing document, revisit what you're doing and why you're doing it, and the locality in which you operate your beneficiaries, and see how that sits. I mean, I think this question about the spiritual faith leaders and the trustees being the same individuals is very tricky, and there are lots and lots of organisations where that is the case. And I think, firstly, you have to understand what are the responsibilities of trustees to have the benefit of charitable status, which is not insignificant. There are certain requirements under charity law and duties that trustees have to perform in terms of oversight of the charity and its operations. So how does a board of trustees that's made up primarily of the staff of the organisation exercise oversight? Well, I think that's very tricky. So I think there are some genuine conversations to be had as to whether it isn't appropriate to ensure that there is a split between those faith leaders and the spiritual leaders and the trustees, or at least an amalgam, so that the faith leaders don't necessarily have the majority, unless they are prepared to split in their own mind very clearly their duties and responsibilities on the one hand as a faith leader and the other as a charity trustee, because those things are distinct, and I think it can be quite hard to hold them in tension. So I would want to be having just a look at how that all works, and is it working effectively? Might it not be appropriate to try and bring in some splitting, parting of those responsibilities, or sharing of those responsibilities, to make the organisation more effective, but also to make sure that it is properly run, that it has proper oversight. Because I think, again, we don't just think about the people we have in our organisation and our sort of narrow cohort, but people who are making donations, for instance, are very alive and alert to whether charities are well run or not, and will want to make sure that standards on safeguarding or whatever it might be are maintained. So I think we've got to be careful not to sort of muddy too many waters, bring too many things together, but actually make sure that all the different strands of responsibility that go with being a charity trustee and go with being a faith leader are recognised and covered. So that's a bit of a long, complicated answer, and may take you down a road, whoever asked that question, you don't want to go down. But I think it needs to be addressed, because I think if you look at some of the Charity Commission inquiry reports into some of ones on faith charities in particular, you'll see that many problems arise where essentially the faith leader is in charge, although he or she has no trustee responsibility. They call all the shots, they spend money, they do things, and in the inquiry cases, of course, they're doing things that they probably shouldn't have done, either with money or whatever. And those inquiry reports always end with a section called lessons learned, and that's designed for the entire sector to try and learn from those things. So if you're grappling with that issue, or you're thinking about it, worth looking at the inquiry reports. They're the horror stories, they're the worst case end, where you never want to end up, but they do provide some helpful insight into where people have gone wrong. Well-meaning people who started off well-meaning and have lost their way somewhere along the line. So those things can be very helpful as well.
Okay, great, thank you. I think we've probably got time for one more question. So the question that's been asked is whether you advocate appointing trustees for a limited term of office which can be renewed. And in this particular charity's case, new trustees are appointed on that basis, but there are still some that were appointed on open-end basis many years ago. And in which case should they look at amending their constitution so every trustee is on a limited term of office and therefore equal?
I think the straight answer is yes, that's a very good idea, because it is the case that trustees who have been around a long time bring a lot of benefit. They have an institutional memory, they know a lot, and that can be very helpful. But if all of your trustees have been in position for a long time, then there's no fresh thinking on the trustee board, people are doing things the way they've always done them. That's not to say people who've been around a long time aren't open to new ideas, but the danger is that it becomes a bit of a sort of cozy club and network of people who've been running it a long time. And I think there's a lot to be said for terms of office. So the Charity Governance Code, which I mentioned earlier on, recommends three-year term for a maximum of 9 years as being appropriate, so that you are appointed for 3 years and can be reappointed and serve up to 9 years. And I think there's a lot of merit in that. Some organisations, including a charity I'm a trustee of, you do 2 4-year terms, but if you've come on to if you're a chairman of a committee, or you become chairman of the charity or chair of the charity overall, then you could serve another 4 years, making 12. So broadly speaking, it doesn't lose people, after 8 years, if they could be effective in a role for an extended period of time. But I think the principle of appointments which come to an end when people step down, and of course it doesn't preclude them from taking 2 or 3 years off and then coming back. It just says 9 years in a row, then have a break and maybe come back if you're needed, missed, want to have the energy, etc. to serve. I think that's definitely worth thinking through. The only thing I would urge, caution, make sure you don't retire all your existing trustees all at the same time. You'll have to have, even if you've got some in place, you'll have to have a staggered retirement, so you don't lose all that institutional memory and all that long service in one go. But certainly look at it for sure.
Yeah, I would echo that and say that the key to balancing equality of opportunity and the practical need to ensure the preservation of expertise, and indeed the handing down of expertise from generation of trustee to generation of trustee, is to have articles of association that provide for retirement by rotation, but also the opportunity at the annual general meeting for the members to move, the wider members to move, that somebody new should be appointed director. And of course what you have then is a very public selection process, because the incumbents in my organization, my charity, that they have to justify their re-election and go up in front of the members.
Okay, brilliant. Well, thank you both. Unfortunately, we are rapidly running out of time, so I think we're going to have to draw a line under it there. But thank you, everybody, for your questions and your other comments, for taking part today, making all this as interactive and as useful as possible for you all. And of course, a big thank you to Gordon and David for your presentation and for your answers to those questions. The presentation is available to download. If you click on the description of this session, you should find a link to a PDF. And as Gordon mentioned earlier, that's got his and David's contact details on there. And I think they're on screen at the moment as well. So as I say, that's it from us for now. Hope you have enjoyed this session and will take part in all the others this week. It's an interesting programme with some good sessions still to come. So thank you again.